What happens when a council says parts of its private rented sector are contributing to poor housing conditions, antisocial behaviour, fly tipping, and neighbourhood decline? And what happens when landlords fight back? In October 2023, Luton Borough Council introduced new selective and additional licensing schemes, arguing they were needed to tackle housing and neighbourhood problems in parts of the town. Landlords strongly disagreed. What followed was a legal battle that would last more than 2.5 years. A landlord body, Luton Landlords, and Letting Agents Limited. The campaign group launched a legal challenge, forcing the council to admit errors, and the scheme, along with a new additional scheme, was put on hold. It launched a selective licensing consultation in 2023, but this suffered further delays. The case is the latest in a number of challenges against local authority licensing schemes. Landlords in Thurrock have managed to halt the Essex Borough's selective licensing scheme following a High Court ruling, while Leeds Landlord Lobby Group is raising money for a judicial review, and Eastern Landlords Association is considering taking legal action against Great Yarmouth Council. A similar bid. The dispute would move through the High Court, then the Court of Appeal, and ultimately reach the Supreme Court. Luton Landlords and Letting Agents argued that the council acted irrationally or unlawfully in relying on data included in a 2019 report when making the designations in October 2023, that the executive was given false and misleading information about the financial viability of the schemes, and had acted unlawfully in requiring applicants who applied early for a license to pay a fee which included both an amount reflecting the cost of processing the application and an amount reflecting the costs of enforcement of the licensing regime. Now, in May 2026, the Supreme Court refused permission for a final appeal. The legal challenge is over. The landlords have lost. The council has won. And from the 1st of June 2026, Luton's licensing schemes are officially in force. So why did the council believe these powers were necessary? Why were landlords prepared to take the fight all the way to the UK's highest court? And what does the outcome mean for landlords, tenants and councils across England? To answer that, we need to go back to the evidence that led Luton Borough Council to introduce the schemes in the first place. The council argued that parts of Luton were experiencing persistent housing and neighbourhood problems linked to some privately rented accommodation. Evidence relied upon by the authority pointed to poor housing conditions, Category 1 hazards, property management failures, antisocial behaviour, waste issues and environmental concerns in certain areas of the town. Luton's position was that most landlords were responsible and compliant. However, it argued that stronger regulation was needed to identify and deal with those who were not. Using powers contained within the Housing Act 2004, the council introduced two separate licensing schemes. The first was an additional licensing scheme covering the entire borough. This extended licensing requirements to smaller houses in multiple occupation, often referred to as HMOs, which fall outside the national mandatory HMO licensing regime. The second was a selective licensing scheme covering the town centre and park town areas. Unlike HMO licensing, selective licensing can apply to privately rented homes occupied under a single tenancy and other residential properties within a designated area. In simple terms, landlords of qualifying properties must obtain a license from the council and comply with license conditions relating to the management and condition of those homes. Supporters of licensing argue it helps improve standards, raise accountability, and tackle rogue landlords. Critics argue it creates additional costs and administrative burdens for landlords who are already complying with the law. That disagreement became the basis of the legal challenge. Luton Landlords and Letting Agents Limited sought a judicial review of the council's decision. The challenge first came before the High Court. However, the court refused permission for the claim to proceed, finding that the claimant company did not have sufficient interest or legal standing to bring the challenge. The landlord body appealed. In January 2026, the Court of Appeal dismissed the appeal. Lord Justice Lewis agreed with the High Court's conclusions and also found there was no arguable ground of challenge capable of succeeding. The claimant then sought permission to appeal to the Supreme Court. That was the final legal avenue available. In May 2026, the Supreme Court refused permission to appeal. The judges concluded that the application did not raise an arguable point of law. That decision brought the litigation to an end. With the legal challenge defeated, Luton Borough Council moved ahead with implementation. The schemes officially came into force on 1 June 2026. Landlords with qualifying properties must now apply for a license for each eligible property. To obtain a license, landlords must meet specified standards and comply with license conditions designed to ensure homes are properly managed. The council has also introduced an early bird application period running until the 31st of August 2026. During that period, licenses are available for a reduced fee of £150. The fee is split into two parts. Part A is £122 and covers the processing of the application. Part B is £28 and contributes towards monitoring and enforcement activity. If an application is unsuccessful, the Part B element is refundable. After the early bird period ends, the full license fee will apply, with fees ranging up to £366 depending on the type of application. Following the court victory, Councillor Aliyah Khan, Luton Borough Council's portfolio holder for housing, welcomed the outcome. She said successfully defending the legal challenge would allow the council to continue improving housing conditions and neighbourhood standards. She also stressed that most landlords are responsible but said the schemes provide additional powers to deal with those who are not. And that is where this story becomes larger than Luton itself. This case arrives at a time when local authorities are already exercising greater powers within the private rented sector. Since the expansion of council enforcement powers under the renters' rights reforms, local authorities have been given stronger powers to investigate potential breaches, gather evidence, inspect properties, and enforce housing standards. Those powers sit alongside the ability to impose civil penalties and financial sanctions, where landlords fail to comply with their legal obligations or breach regulatory requirements. Against that backdrop, the outcome in Luton is significant. Not only has the council successfully defended its licensing schemes through the High Court, the Court of Appeal and the Supreme Court, but those schemes now sit alongside a broader framework of increased regulation and enforcement. For landlords, the message is becoming increasingly clear. This is a period of greater compliance, greater scrutiny, and tighter regulation across the private rented sector. For tenants, the expectation will be that stronger oversight leads to safer homes and improved housing conditions. And for councils, the Luton case may be seen as a significant endorsement of their ability to use licensing powers where they believe there is sufficient evidence to justify intervention. The legal battle is now over. The Supreme Court has closed the final route of appeal. The licenses are being issued, and as councils continue to expand enforcement activity across the private rented sector, the Luton case may come to be seen as part of a wider shift towards stronger regulation, enhanced enforcement, and increased accountability in housing management. Whether those measures deliver the improvements councils hope for remains to be seen. But for landlords in Luton, the new licensing regime is no longer a proposal. It is now a legal requirement.